Elkhammer, case number 24C-2349.
Good afternoon, Judge. Francesca Zhu for plaintiff P87205.
Good afternoon.
And this is David Elkhammer, representing myself.
Thank you. Good afternoon, sir.
Hi.
All right, we're here today on your motion, Mr. Elkhammer, to set aside the default in this particular case. You have, so for a motion to set aside a default to be successful, you have two prongs that you have to meet. One, that there's good cause for the fact that you failed to appear in the first place.
Yes.
And two, that there's a meritorious defense, like you have a good defense to the case itself. So, first of all, did you receive the response, the answer that came from the defense counsel to your motion, sir?
You mean from plaintiff's attorney?
Plaintiff's attorney.
Yes, from plaintiff.
Yeah, yes, I did. I read it carefully and I can respond to that. In addition, I would like to respond to the 2 points, the failure to answer and the meritorious nature of the defense.
All right, you may proceed, sir.
Oh, thank you so much. So in terms of failure to answer, I believe I have a good cause for failing to provide an answer. I was served on the 14th of October. On the 24th, I contacted plaintiff's attorney directly to attempt to settle this claim. I proposed a settlement agreement at that time. And then on the 28th, I was told my offer was accepted, and plaintiff's attorney emailed me a copy of the settlement agreement, which I believe you have a copy of, as it was included in my motion.
Let me make sure here. I see that there is an acceptance of the settlement. I see that. Okay.
Yeah.
And you have nine monthly payments. Okay.
Yeah, and so I spoke to the clerk's office on 2 occasions. On the 25th, I understand that's not a formal answer, but I checked on the date of service to determine my deadline to answer. On the 1st, I contacted the clerk's office to see if I should file or if I could file the settlement agreement as an answer for the lawsuit. The clerk said yes, but that it would be quote unquote highly unusual, as that is something that the plaintiff's attorney would customarily do. I believed as officers of the court, plaintiff's attorney would be required to divulge the material facts that I had contacted them, acknowledge the debt, entered into a settlement agreement, and started making payments. And as such, I believed I did not have to file an answer. It was unnecessary once plaintiff attorneys filed the settlement agreement with the court. I meant to call the court. I knew the deadline. But once I started making payments and I had the settlement agreement, it kind of escaped me, and I didn't call to check that they had filed the settlement agreement or that I still needed to answer. So
are you still making payments on it, sir?
Pardon me, ma'am?
Are you still making payments on it?
Yes, ma'am. I've made 3 payments now, so I only owe $700 at this point.
Mm-hmm.
And then in terms of providing a verified statement of facts, I have no meritorious defense to the original claim. That's why I called them up and settled.
Gotcha.
It's my shell card, of course. My name, and there's only one David Elkhammer in the world. My grandpa made that name up when he came over from Sweden. So there's no confusion. That was my shell card. And in fact, until they provided the 40 pages of stuff, I didn't know what it was. I could not find this on my credit report. But if it's my name and it was obviously my debt. So I accepted it and entered into the settlement agreement. And so, yeah, there is no meritorious defense to the lawsuit. I acknowledge that by calling them up. And then I would just say, in point 3 of their answer, they state, setting aside the judgment would be futile in any event because the evidence clearly demonstrates defendant's liability. They say it is abundantly clear the defendant is liable. Well, I agree with that. And that's why I called them up and settled the debt. I have no meritorious defense for the original lawsuit. I thought I had settled it. Okay, so they maintain it would be futile as I would not prevail as the case was litigated. There would be no litigation, just the settlement agreement that's already in place. I would continue to abide by the settlement agreement. Their client would get an additional $700 on this 5-year-old debt, and I would know where I stand. It would fix my problem of having 2 contradictory legal documents indicating I owe 2 different amounts for the same debt. and I respectfully request that you grant my motion to set aside this default judgment and allow me to just complete my settlement agreement.
Thank you.
Just paying. Thank you so much.
Thank you so much. Ms. Serby, please explain.
Yes, Judge. Plaintiff relies on its pleadings as they submitted. There was no answer timely filed, unfortunately. And
Ms. Serby, why should he be filing the answer when he clearly has in front of him a settlement agreement from October 28th? Why would anybody from your office come to court and get a judgment against someone that you have in writing, you have an agreement with?
Judge, I was going to state that, I mean, in light of that, I don't know how that necessarily slipped my desk, but we will still honor the settlement arrangement as it was agreed to originally. So, I mean, there was no answer filed and there's no meritorious defense, but at that, plaintiff will still honor the settlement arrangement. And once that's received, once that $1,000 is received, that will still be considered settled in full.
I don't know what that means with respect to this judgment that you came to court to get when you. It would be different in my mind if he was dealing with a different law firm. This is the same law firm. You reached an agreement with him, you send him a settlement letter, and yet you still prosecute the case. You can't do both. That is a meritorious defense. You settled the case. So the motion to set aside will be granted. You can dismiss it, you can do whatever you want to do, but I'm granting his motion to set aside in this particular case. You guys need to talk to each other. You can't reach a settlement and then come into court and default him all at the same time.
Understood, Your Honor. Thank you very much.
So do you want a pretrial date, or are you going to send over a dismissal, or what do you want to do?
What we could do is, we could do just a stipulated order of dismissal then with the same settlement parameters that were already outlined in the previous, so that it's closed out on the court's end.
That sounds great. So what I'll do is I'll set it for entry of order date, give you time to get that document. So what they'll do for you, sir, is hopefully, I don't know, that's up to them, but hopefully it'll be a conditional order of dismissal that puts these terms in place, that if you don't follow those terms, then what will happen is the case will get reinstated and they can go after the full amount. Okay?
Yes, ma'am. And I'm paying this out of my Social Security card as soon as I get it, on my Social Security check. And there's no problem paying with that at all.
Okay.
I have 7 more payments. I'm paying it on my Social Security as soon as I get it. The payments have been early.
Yeah. So how long for entry of order? Do you want me to put that in late February for you? So that way you'll see more history of payments or something?
That works, Judge. Yes, that works.
So I'll put this on February 27th at 3 p.m. What that means for you, sir, is that they should send you a document that puts all these terms into writing regarding this case. You need to sign that, send it back to them so that they can file it with the court. If that document is filed, then no one needs to be here on that date. Okay?
Yes, ma'am.
All right.
And Mr. Elkammer, it'll look very familiar to the one that we had already sent you as well. And it'll just outline that those monthly payments are to be made on the date agreed upon. And then once the $1,000 is received, it'll be settled in full. I apologize for this oversight, but we'll get that fixed and sent over to you very shortly.
All right. Thank you.
Thank you.
And, hopefully I don't have to see you guys, but if need be, it'll be February 27th, 2025 at 3 p.m. for entry of order.
So from my standpoint, you have granted my motion to set aside.
I have granted it, correct.
Excellent. And they're going to send me some paperwork, kind of reorienting this into the case, but along the same terms that we've already agreed.
The same terms, the exact same terms.
Okay, great.